Hey, Realtors, it's Austin with the SCR legal team to walk you through some of the upcoming changes to the sales contract that you'll be seeing in a few weeks. The first major change was in paragraph 6. This was the changes here were to add some clarity and hopefully clear up some of the questions we get about this section. The first is in paragraphs 1 and 2. We added in a reference under the broker compensation to make sure that you're aware that that is the amount of compensation the client still owes their broker. That does not include any compensation that has already been negotiated with a different party. But this is simply, what does the buyer still owe their buyer broker? What does the seller owe their broker? And then in paragraph 4, when negotiating transaction costs, I want to make clear that the amount you put in there should not include any fees that have already been negotiated in a separate compensation agreement. That amount has already been negotiated to be paid, so you do not need to ask for it a second time. Do not need to reference it a second time. That is compensation agreement is wholly separate from this agreement. And then the parties will pick out if there is the seller is going to pay some of the buyer's transaction costs, whether the seller will allow some of it to go towards broker comp, understanding that that means remaining compensation the buyer still owes their broker, or does the seller not allow any of that to go to broker comp? The next change is not a practice change. It's more of a semantics change and more to kind of make it a little easier to understand. Is the due diligence section, making it more clear that, hey, the buyer can terminate for whatever reason, that the buyer will pay a termination fee if they terminate. But if the buyer terminates under a different contractual contingency, the fee will not be owed, and the fee is only owed if the buyer terminates during the due diligence period, and they have to do so for due diligence reasons. Lays out what at the end of the due diligence period, the buyer must have either accepted the property in its as-is condition, negotiated for repairs, agreed to other sort of remedies through attorney-drafted verbiage, or they've terminated by delivering a notice using 313 and the termination fee. Failure to do any of that will be a result in that as-is contract, and we define what as-is is. Paragraph 9, the only thing we did here is we removed the underlines from this verbiage. It made it appear on platforms like that was added verbiage, so that was not intended, so that underlines have been removed. 17, this is just a rewrite to more align with statute, but the practice stays the same on that information. Broker compensation. This was a change to essentially say that you can, and this aligns with what has been done in other states, that you can reference your compensation in the sales contract, that you can use it as an attachment, and so it's clearly laid out there. And then in paragraph 26, we have instead of having the blanks for contingencies, we've simply said, hey, here's a list of addendums that you're likely going to use. Check the box if any of those apply. And we do have some other lines if they're ones that we have neglected, or if there's a separate contingency drafted by an attorney or your brokerage has one, etc. The last final change was some references on the notice address. So that is a question we get a lot is, hey, do we even need to fill that out? Yes, that is incredibly important information, because you will see in paragraph 27 that all notices must be in writing are only effective as delivery to the notice address, email, fax written below. So you actually are not considered to have notice if it's not sent to the notice address. So that's where we're going to remind everybody they should fill this out. And that we're not probably asking for the buyer or the seller's address, email, unless it's a very unique scenario where they want the communication, that the contact information, the notice address, email, fax, can be that broker's email and address. And even made a reference for the buyer saying, hey, where does the buyer want all contracts and correspondence to be sent? And for the seller, where do you want all contracts, correspondence, and termination fee to be sent? So those are the changes to the sales contract. I did want to make a note that you will see that the home warranty section has been removed from the sales contract. That is because that is being made its own separate addendum that I'm going to detail in a separate video. But if you now wish to do a home warranty, that will simply be an addendum, and that addendum is referenced in that attachment section. So if you have any questions on this form or any of our other forms, feel free to give us a call on the legal hotline. We'd be more than happy to assist. Thank you.